Contracts. You can set them up to increase your chances of success. And that's what I want to talk about today. Outcomes are uncertain. Any lawyer will tell you that. You don't know what a judge or jury is going to do. You don't know what a counterparty in a business transaction is going to do, particularly if the transaction goes sideways, if they encounter financial difficulties. But there are a lot of things we can do within contracts to increase our chances of success. So as a lawyer that practices, that does a lot of contracts, I want to spend some time talking today about what do we do in contracts to increase our chance of success. It's something that a lot of people are missing, and some of this is just fundamental blocking and tackling that you can add to your business and your business processes and potentially fundamentally change your outcomes. Your contracts are just an agreement. If you go back to the basics of contract law, you need to have an offer and an acceptance. That is what forms a contract. One person makes an offer, and the other person accepts that offer. In general, those offers and acceptances need to be identical to each other in order to have a contract. If there's a counteroffer or a different term, then you don't have a contract. But some of that varies under the UCC, the Uniform Commercial Code, which governs the sale of goods, where you may not need that. But in general, you need a matching contract. Offer, acceptance, we all agree to the same terms. Usually people execute these, put their name on the bottom of the contract, put their little signature down there, and we're off and running. Where a lot of people, particularly smaller businesses, miss the boat is they don't think about how to set up and structure those contracts early in the process. Before that contract's ever signed, we're in that contract negotiation phase where we typically have drafts going back and forth. That's a great time to work on those terms and conditions and make sure they really match your business and to make sure they work for you. You know which side you're taking, whether you're the buyer or the seller, and how you need to protect it. And the time to get all your protections is before the contract is signed. So you'll want to think about negotiating power, what you need, what will be helpful to you as a business going forward. And you want to start putting all of that into the draft contract. So think about that in the contract negotiation phase. What are the kick-out clauses? What causes the contract to terminate? What happens after contract termination? Will that non-compete, will that non-circumvention provision still work? Will they be bound by that, the other side? What if they default? What if they don't do what they're supposed to do? How do you get repaid? How do you get made whole? These are all questions to ask, and a lot of this is what if gaming with the contract. Well, what if this? What if that? What if the relationship goes south? What if the other party doesn't want to perform? These are all questions you can ask yourself before you sign the contract. The more you ask yourself those questions, the more you get that documented in the contract, the more protected you're going to be. It's why it really makes sense to get that contract negotiation phase down. And if you're a routine seller, if you're selling the same good or service over and over again, this is a great time to focus on that form. Get that form to where you want it to be. And depending on the nature of your customers, they may either just sign your form or you may have negotiations, but you want to have a good starting point for negotiations. So sit down with your lawyer, discuss where you're going, discuss what your business is, what issues you've had in the past, what have been some common sticking points, what have been some problems with customers or vendors in the past, and start working all that into your contract. The time to do it is now. Get that in your contract. It'll make a big difference. If you have general questions, go ahead and drop them below. Questions on a public social media channel like this are not confidential, so other people might see them. Don't put anything there you don't want other people seeing. For confidential communications, meet with an attorney of your choosing. I hope you subscribe to the channel for more videos coming up. Thanks for tuning in today, folks.